Yes.
Under the heading hearing under order 41 rule 11 of CPC serial number 26 second appeal 74 of 16 Mr. Neeraj Kishore, Ms. Vandana Kumar Sinha, Mr. Ashwara Prakash, Mr. Shri Prakash Jha for respondents.
Yes, please. Well, it is defendant second appeal against the judgment of the Muscle. Well, what has happened in this case, my lord, the plaintiff filed a declaratory suit for declaration of his title, right, title, interest and possession, as well as there was a specific relief, my lord, for setting aside the one of the order passed by the revenue court, wherein the lands entries in the record of right has been corrected in the name of the ancestor of the defendant. Now, this was the specific relief, and on that basis, if my lord, I will thereafter subsequently come to the facts of the case. Well, the first phase of the trial court judgment is very relevant. First suit was decreed, thereafter appeal was referred, appeal was remanded, and the first paragraph my lord will find. The suit may read.
Yes.
Now, the suit is remitted back, and a specific demand, my lord, was made to frame specific issue with respect to compliance of section 80 CPC notice, with respect to suit was banned for non-vendor of necessary party. These were the specific issues where the demand could have remanded the matter. Now, thereafter, my lord, the issues were framed, separate issues were framed, and thereafter, my lord, trial court has specific head in paragraph 13 and 14 of its judgment. 14, on the basis of admission, my lord, of the plaintiff himself.
Admission. Admission in the plaint.
No, not claim, my lord, that they have.
No, admission in the plaint or admission during
no,
the
admission in the evidence. During his cross examination, my lord, he has admitted, my lord, I will refer the trial court judgment also, paragraph internal page 30. That he has knowledge of the revenue court's order, and that's why, my lord, the trial court has here.
You are taking the ground of limitation.
No, I am saying that, my lord, and thereafter, my lord, we find, my lord, the what first appellate court has done, my lord. These issues which were subsequently remanded, and these issues were subsequently tried by the lower court, trial court, my lord, nothing has been discussed. On what point it has been reversed, my lord, the lower appellate court has what done, my lord. He has placed, my lord, burden upon defendant to prove his title, and my lord, nothing independent finding has been given so that to give any reasoning to meet the reasons given by the trial court, my lord, internal page 16 of the lower appellate court. From lower paragraph, my lord, will find.
Just a minute.
Running page 42. Internal title of the 22,009 पे इंटरनल पेज 16 है जजमेंट.
Yes.
So, my lord, my first submission, my lord. Now, my lord has seen the findings of the lower appellate court, my lord. And my lord, kindly have a look to the internal page 13 of the my lord, paragraph 30, my lord, internal page 14 of the trial court judgment. My lord will find.
Yes.
My lord, may I read, my lord? It appears that in the remarks column it is mentioned that no land is mentioned therein. Secondly, the revenue officer has also found and held in his order dated 2/82 in the aforesaid revenue case that the settlement of name of the suitor in the name of the Nimati Dusad was not according to law. This was the ancestor of the plaintiff. In this regard, it is admitted case of the plaintiff that the suit land was settled in the name of his father during the year 1970-71 during the pendency of the aforesaid revenue case number so and so filed by Naro Dusad minority defendant and passed by the which is corroborated and subsequent by exhibit B as discussed. In this
Mr. Thakur? Mr. Thakur?
Yes.
Where is the consideration of the issues by the first appellate court? Where is the consideration of the issues? The court has, first appellate court has to independently adjudicate each issue. The court goes on the judgment of the trial court.
So this is in conflict of order 41 to 31 mandatory provisions.
Yes.
Initially, the title suit was decreed law that got demanded by
No.
appellate court law.
Forget about the degree.
Uh,
Because after it was decreed and an appeal was filed, the appellate court set aside that decree and remanded that you cannot take any benefit of that. Can anyone take any benefit of that when you have not challenged? This appeal will be heard on the following question of law. Whether the first appellate court failed to appreciate the provisions of Order 41, Rule 31 of the CPC while considering the appeal, full stop. Whether it was incumbent upon the first appellate court to adjudicate each of the issues which were framed independently based on the evidence, and by not doing full stop, whether if it is held that the first appellate court has not has violated the provision of Order 41 Rule 31 and has not considered and any further question of law which may be framed. Call for the local reports. Trial court by appellate court.
Appellate court has framed law.
No.
Demand order has not been challenged.
The appellate court's judgment runs in how many pages? Tell me. It runs in 18 pages. Till 15 page, he only quotes the plain written statement, the evidence, everything. He quotes. But none of the issues have been taken up for decision. You should have done that.
Serial number 27, second appeal 104 of 16, Mr. Shailendra Kumar Singh for the appellant, Mr. Rahul Kumar Das, Mr. Pranesh Kumar Das for the respondents.
In this case, Lord, your appellant is filed a petition before the civil court, Lord, for the declaration of the null and void of the gift and the will deed, Lord. Will and gift. On the basis of the Harji or certificated gift and will deed, both court has decided the right possession and title over the fruit land in favor of the defendant, respondent and respondent proceed. Here, in each case, in nutshell, that there are two suit land properties lawsuit, Schedule A and Schedule B lawsuit. In Schedule A property lawsuit, Jharkhand has purchased in Schedule A lot, which is RS Khata number 150 plus 152 lawsuit. Total area is 6.03 acre lawsuit, which is in the name of Jharkhand lawsuit. And Schedule B property is the joint property.
Show me the plate.
Lawsuit. Yes, land.
You have got the plate with you.
Land lawsuit. Case 30 lawsuit.
Where is the plate? You have got the plate with you.
Yes,
Show me.
land filed by the plaintiff lawsuit.
No, it is on record.
Is lawsuit.
Page
Case 30 lawsuit.
30.
30.
30 is the schedule.
Schedule A property authorizes lawsuit to purchase land for the Jharkhand and Schedule B property
Let us see what is your prayer.
in the name of the joint property lawsuit Jharkhand and his brother Jharkhand lawsuit.
The will was probated.
No.
Then
Defendant has
in
the nuts and lawsuit. This Schedule A property is
first have you answer this question. What is the effect of an unprobated will?
first they have filed partition suit.
I am asking you on your prayer. You have prayed
Yeah,
that
prayer is
the
the
will be
lawsuit.
declared null and void, inoperative.
Lawsuit.
So the will has not yet been probated.
Lawsuit.
So
And they have both the court have not framed the issue on this basis.
why the issue should be framed? The will has not yet been probated. Is your suit maintainable?
No.
Answer this question. You file a title suit for declaration of a will to be bad, void, inoperative. No one has come forward to probate that will. And if the will is probated, what steps you had taken when the probate application was filed?
First, they have no knowledge about plaintiff has no knowledge about the will and will. First, they have filed partition suit. In the WS, they have
So, first tell me whether the will was probated or not.
no knowledge.
Then, what is the effect? What is the effect of that will? What is the effect of that will?
So that is my prayer, lawsuit. Both are the null and void and faulty lawsuit. Not
Will is in whose favor? Not in your favor, definitely.
No.
So, then a will which is not probated, what prompted you to come and make a prayer in a title suit, by filing a suit for a declaration that the will is void, bad? Are you understanding the question which I am trying to put to you?
it is my prayer is the plaintiff lawsuit.
What made you?
Both court has finding is that some portion of the properties born on the basis of the will and gift, and some portion has born on the Ghautama.
You are the defendant or the plaintiff?
I am plaintiff and appellant and appellant.
So that is why I am asking you, what made you to file a suit for declaration of a will null and void?
Yes, 35 years.
Why? Why have you filed that?
In the plain process.
Why? What made you to file that suit?
Suit.
What made you to make that prayer? What made you to make that prayer in the suit that this the will is void, null and void and inoperative?
Just I want to say something else. This is the case that Moja is the guardian of the both property are situated the guardian, card holding, and political appellant.
This is not the answer
Look,
to my question. What is the effect of a will which has not been probated? Tell me.
no, will and will are both are worthy of.
Who will decide? In a title suit, or when there is a specific provision under the act, under the law, Indian Succession Act? Tell me.
Yes.
What is an effect of a will which has not been probated? Tell me. What is the effect?
Inoperative, it will become inoperative also.
So then who told you to file a suit for that purpose? Who told you to file a suit?
That is.
पढ़ के ये बढ़िया से. This case is adjourned for 3 weeks. And your second point is possession. Second claim. Both the courts have held that you are not in possession.
At the time I was.
Both the courts have held that you are not a possession. It's whether you are in a possession of a particular land over a particular land or not is an absolute question of fact. So, how can this court decide?
Serial number 28, second appeal 137 of 16, Ms. Rita Kumari, Ms. Neetu Singh for the appellant.
Yes.
May I please the doctor? We are defendants, appellate and appellant.
Yes. Where is this judgment in title suit?
Pardon me?
Where is the judgment of the title suit?
It is at page
Page
25.
25.
Where is page 25 of the trial court?
Yes. Travel. Suit for partition.
Suit for partition law. Now the point for your lordship not consideration is that the plaintiff defendants Lord are claiming the land from मुसलमान तेजरी देवी जिसकी दो बेटियां थी गुलाबी देवी और सुखनी देवी और दोनों का वो डेथ हो जाता है और एक ये कच्चा झोपड़ी टाइप का घर था और plaintiff now the point is Lord that in view of the we are the defendants Lord हम लोग दूसरी डॉटर्स हैं दोनों डॉटर के बच्चे लड़ रहे हैं plaintiffs and defendants. Now the plaintiff claims share Lord in this house property and when he comes to court Lord he admits if for the last 30 years or more not residing in that kacha house and it is the defendants Lord who constructed the house. They were living somewhere up elsewhere Lord and Lord our claim was that there was a suit with one Kisan Lal Popli title suit in which Milord, he got the lands attached, Milord, and that was Milord Gulati Devi and Subhani Devi, both the mothers of the plaintiffs and defendants. They were defendants in that title suit. Milord, Subhani Devi relinquished her claim. She left, Milord, and she said कि इसको तुम ही लड़ो, हमारे पास नहीं है. And that is 30-40 years back, Lord, she started living in some another mahalla in some rented house. Now the question for your Lordship's Lord consideration is that in view of the admission that the house has been constructed by me by my own fund, Lord, can there be a partition in that, Lord, and share, claim share, Lord? So therefore,
I am putting a question to you.
pardon?
I am putting a question to you.
Milord.
And admittedly, the property is shown as a joint family property. Property is recorded in the joint name.
Nani ki hai.
Yes.
Mother Musammat
It's
Patri, mine.
yes. So after the death of this Patri, who will be the shareholders of this property, owner of this property?
Both daughters.
Both daughters.
She had only 2 daughters.
Was there any partition, previous partition?
No previous
No,
partition.
there was no. Only on the basis of possession you are claiming?
Possession.
In a joint family property, possession of one means possession of all.
True, man.
Then?
But in view of the admitted facts and evidence.
Yes, even if I admit.
नहीं, हमने अपने पैसे से जो चीज
Yes,
बनाया,
yes.
उसमें वो उस पार्टीशन में शेयर कैसे उसको हुआ है? This is what I want to bring home to this honorable. वो portion
You can bring it.
then please.
So in the partition, that portion will be given to you.
Pardon?
When the final decree will be prepared and the property will be partitioned, that portion will be given to you. You challenge the final decree if that portion is given to him.
Portion को वो पूरा मकान ही मेरा बनाया हुआ है.
In the entire land, there is no other land. You face it. You know.
So हमको question is share has been allotted not by both people.
Yes, it has to be. It has to be.
तो जो मकान वो अपने फंड से मेरा बनाया है,
Yes.
उसका निदान कैसे होगा?
You took risk. You took risk. At your own risk and cost, you have constructed the house.
This is what Lord I wanted to drive home to some court, Lord, that admitted is not in possession for the last 30, 40 years.
Admitted is the property is joint. Admitted there was no previous partition. Finished. The property must be partitioned. Then what is wrong? Admitted that you are the descendant of the Patri.
That is admitted. But
only on one point which you are harping is that you have constructed.
Constructed from my own Lord fund.
Making construction.
तो उसमें शेयर कैसे उसको?
क्या नहीं होगा? Why not? Why not? They are claiming he is claiming 1/4.
Pardon?
He is claiming 1/4. He is claiming 1/4 share.
1/4.
Yes, he is entitled to get 1/4 share.
तो कंस्ट्रक्शन वगैरह का उसमें फिर कैसे क्या होगा? जो पैसा लगा हमारा वापस.
Who told you to make value addition of that plot? Who told you to make value addition of that plot?
Construction.
Yes.
जो हम ही रह रहे थे वो तो रह भी नहीं रही थी. And during her lifetime she never claimed any share.
There cannot be adverse possession against a co-sharer.
But in her lifetime she never claimed. Now it is the children who are coming forward.
Yes, definitely.
As
Is there any document that she has relinquished her rights?
उसका कोई डॉक्यूमेंट नहीं है relinquishment but the act I mean relinquishment acted upon as will appear from the conduct.
No.
She never during her lifetime claimed.
No. See, this is a question of not claiming. It is a question of whether she has expressly relinquished or not. Whether she has expressly claimed or not is not the question. Question is whether she has expressly relinquished or not.
Expressly.
She has not relinquished.
वैसे कोई डॉक्यूमेंट हुजूर ऐसा नहीं.
That means, what is the presumption?
हाँ?
What is the presumption in a partition suit?
Presumption.
Presumption is favor that the property is joint. Parties are Hindus. Jointness is the presumption. And you also admit that there was no partition. And the law says that their possession of one means possession of all the co-sharers.
तो शेयर जो अब उसको जो मिलने जा रहे हैं तो उसमें हमको कंस्ट्रक्शन में जो पैसा लगा उसका तो हमको
That cannot be looked into in the partition suit.
हाँ?
That cannot be looked into in the partition suit.
I'll have to go then in the suit.
That is all.
Enlighten my lord. एडमिट किया जाता है
Admit. Dismissed.
Serial number 29, second appeal 164 of 16, Mr. Sri Prakash Jha, Mr. Aishwar Prakash for the appellant, Mr. Atanup Banerjee for the respondent.
मेरा क्लियरेंस उसमें लिखवा दो
एकदम.
मैं मिला
How is Mr. J.P. Jha? Likita on the health ground of Mr. J.P. Jha, Senior Counsel, who will appear on behalf of the appellant. This case is adjourned for 2 weeks. 2 weeks or 3 weeks, tell me. 3 weeks.
Also my experience.
Yes.
Serial number 30, second appeal 173 of 16, Mr. Rahul Kumar Gupta, Mr. Kishay Kumar for the appellant.
Concurrent finding, I am the plaintiff, so dismissed, and then first appeal also dismissed.
What was your prayer?
Prayer was that there was an earlier partition in the year 1945 that culminated into a final decree, but then also no parties acted upon it, and then there were some disputes subsequently which led to filing of the incident suit by the plaintiff again. Now, interestingly, Your Lordship may kindly see title suit, the original court judgment, page 30 onwards. It is in Hindi, but I'll only place very briefly.
Read the prayer first.
Prayer is for, may I read it from the draft of that?
Yes.
It was for declaration that the earlier partition was bad.
Just a minute. वादीगण की इस बात में रीता.
हाँ, हम पढ़ रहे हैं. वादीगण ने इस बात में जनपद के दर्शित भूमि पर अपने 1/3 अंश की प्रारंभिक डिग्री एवं अधिवक्ता आयुक्त के माध्यम से सीमांकित किए जाने का अनुरोध मांगा है. वादीगण ने अंतिम डिग्री तैयार करते हुए वादी को पृथक करने एवं दखल दिलाए जाने का अनुरोध का भी निवेदन किया है तथा बंटवारा वाद संख्या 43 ऑफ 1945 में पारित अंतिम डिग्री एवं उसमें कब्जे के दिनांक इतना को हस्तगित होने तथा 11/8/1991 को संपुष्टि को अप्रभावकारी, शून्य एवं अतिरिक्त होने घोषित करने का
How can that be?
No, what has happened? Ultimately, what has happened that the trial court held that I had as a plaintiff. There were 3 brothers who were surviving. I had 1/3 share. This is the finding of the trial. But then it said that since these properties were already involved in the earlier partition suit and there was a final decree, therefore this is barred by res judicata. That I do understand. What you achieved, what I could not get. Therefore, I could not get what would happen in a case where ultimately I was held that I had a right on the property and I had 1/3 right. And in earlier partition suit also similar finding was there, but no final
Finality was not prepared.
No, it has come that it was prepared and legal commissioner report was submitted, but nothing further happened. Then what would happen? I could not get the correct law. What would happen in a case where it is ultimately not executed or
No, just tell me. A final degree proceeding was initiated?
It seems that it was initiated.
So it must have culminated.
No.
No, it can't. How can that be? Final degree proceeding is numbered separately.
Even if final degree proceeding were, let us assume that it had culminated, then what would happen in a case where even after final degree, it culminates into a final degree,
yes,
and it is not executed, then what would happen? I could not get the law. I must clearly admit that I could not. What would happen ultimately is that, let us assume that a particular
both the courts are aware that
there
it was not acted upon.
because the court has come to a finding that I have a right, 1/3 right on the suit property, but because all these were involved
But the case, this suit itself was barred by res judicata.
that I do understand my difficulty, but whether in a case where a final decree is prepared, because I have a right on the property, and final decree is prepared and it is not executed, then what would happen? Because I have not been able to get that law. Why I must clearly admit. Because it cannot be that after preparation of final decree, it must have been any decree has to be executed within 12 days.
So
It has to be executed.
how do you know that it has not been executed?
No, that is the case of the party. It is not in dispute that
Both the
it has
parties?
not been. Yes, that is not in dispute. That is no. The courts below have also not come to a conclusion that it was executed also. The courts only come to the conclusion because now your relevant finding I may be allowed to place. The trial court itself is very clear, and I must admit that he has thoroughly discussed the matter. First, internal page 8 of the trial court judgment your Lordship may see, he says that suit is not bad for disjointed and non-jointed. Then important issue is relevant finding is
The res judicata.
no. First is that I have a right on the 1/3 right. That is there.
So that was also held in the earlier suit also.
Yes. In internal page 11, your Lordship may kindly see. Internal page 11, last 5 lines of the first paragraph. Middle portion. तदनुसार यह बात बिंदु
Internal page?
internal page 11 and running page 40.
Yes.
After 8 lines approximately. तद अनुसार यह बात बिंदु आंशिक रूप से वादीगण के पक्ष में इस प्रकार से अभिनिर्णित एवं विनिश्चित किए जाने योग्य है कि पक्षों के मध्य विवादित भूमि खाता संख्या स्वयं के लिए पक्षों के मध्य स्वत्व एवं एकता के कब्जा की संयुक्ता है और वादीगण किसी संपत्ति के 1/3 अंश के पात्र है। तदनुसार वाद बिंदु 3 और 6 आंशिक रूप से वादीगण के पक्ष में दिया। This he says. Then what res judicata has been held. that res judicata starts from next discussion and relevant portion I am placing. Next page, page 12, middle portion.
What is the defense taken by the defendants?
That there was an earlier partition.
And thereafter it was acted upon. They must have said that it was acted upon. They must have said that it was acted upon.
They do not say that it has been executed or all those defenses are now.
Where is the written
there is
statement?
no such finding.
Where is the written statement?
Just. May I read it out?
He denies this line. It is not correct to say that the allotments in suit 43 or 45 were not adhered to. Coupled with the fact, his specific statement that we have sold several lands thereafter, which shows that the partition was given effect to.
But the finding of the court, trial court, I may be allowed to read the internal page 14 of that. Just 5 lines prior to para number 29. इसलिए इस कार्रवाई के आधार पर पूर्ववर्ती किसी डिग्री को पक्षों द्वारा न मानने के विषय साबित नहीं हो रहा है। सबसे बड़ी बात यह है
डिग्री को ना मानने का
सर सबसे बड़ी यह बात है कि पूर्ववर्ती वाद की कार्रवाई अभी तक विधि के अंतर्गत समाप्त नहीं हुई है, विधि के अंतर्गत पूर्व की कार्रवाई मीन्स 1943 डिग्री विधि के अंतर्गत समाप्त नहीं हुई है और उसमें कोई अंतिम डिग्री पारित ही नहीं हुआ है, तब ऐसी स्थिति में किसी अंतिम डिग्री को पक्षों द्वारा मानने न मानने का therefore
from where this finding is
internal page 14 para 29 just before para 29 5 lines. Since this was in complete or difficult Hindi words, therefore and then the next page, page 15, last para 30, last 4 lines. Page 15, last 4 lines, para 30. उपरोक्त विवेचना के आधार पर मैं बताता हूँ कि वादिगण इस विषय को साबित नहीं कर सका है कि पूर्व में कोई अंतिम डिग्री पारित होकर पूर्ववर्ती वाद अंतिम हो चुका है, जिसे पक्षकारों ने पूर्ववर्ती किसी अंतिम डिग्री को अमल में नहीं लिया है और वह प्रभावहीन है, बल्कि वादिगण ने बिना पूर्ववर्ती वाद को कार्रवाई समाप्त हुई।
The court holds that the final degree proceeding is still in progress.
Yes, it has not culminated. It
So if that be so, then also it is not maintainable.
I must admit, Your Lordship, it is not absolutely clear from.
See, if it has been held that the final degree proceeding has not yet culminated, then also your case is not maintainable. Your suit is not maintainable. If the court holds
But
that it
at
has
one
not
point of
culminated,
time, it has come that final decree has
it
been
has held
declared.
that.
But it is not clear. Time and again I am repeating, but it is not clear whether it has culminated.
Court says it has
Only
not
Your Lordship, may I
culminated.
take up. Your Lordship may take it up in next week itself. With regard to this portion, I must be absolutely clear.
What is the appellate court?
It's very cryptic. In fact, I must admit that though my suit was dismissed by the trial court, but it is well discussed, but the appellate court does not even go anywhere. It does not even discuss all these things. Very cryptic that it is only barred by res judicata. Internal page 11, it starts mentioning about the earlier suit. Issue number 5 was page 9. Issue number 5, last 2 lines, it says this is with regard to res judicata, and he quotes the section 11